Human rights lawyer Femi Falana has called on the federal government to withdraw and re-examine the list of 175 persons recommended for pardon by President Bola Tinubu. In a statement he issued on Thursday, Falana did not dispute the president's constitutional power to grant pardons, but said the exercise should be reviewed in the interest of what he termed justice and national morality. He argued that the current list includes politically exposed persons, alleged drug barons, armed robbers, terrorists, and people convicted of state offenses such as culpable homicide and murder, and therefore requires urgent reappraisal. We now turn to a lawyer and political analyst, Liberaso Shoma, for his view on these legal matters. Actually, we're joining two things together. 175 people pardoned by the Council of State, and now the attorney is coming back after all the feedback to say that they are reviewing the list. The contention here is, shouldn't this have been done prior to the issuance? And this statement, is it perhaps an effort to rejig that list as a response to the criticism that has trailed it?
First and foremost, thank you. One would have expected ordinarily that the committee, Prerogative of Mercy Committee, headed by the Attorney General, would have done its job, look at the list, make recommendations to the president before the president will grant, that pardon or prerogative of mercy as prescribed under Section 175 of the Constitution. But unfortunately, now the president has granted the pardon. And that is when the committee headed by the Attorney General is now supposedly reviewing. I will not putting the cart before the horse. But that said, it's also a good development. It's a welcome development. It shows clearly that the government is listening to the cries of the people, because we saw the condemnation that greeted that list. And then also, in law, we say when a law must pass the repugnancy test. A law must not be repugnant to natural justice, equity, and good conscience. It must also not be contrary to public policy. So if a law encourages repugnancy and it is contrary to public policy, then it is good that such acts, that is the act that is carried out pursuant to that law, be reviewed. And so it's a welcome development that the Attorney General now, rather than reviewing the list before the pardon is granted, after pardon is granted, is now reviewing the list. It also shows that while we are complaining, they are also listening.
Well, just to interject there so that we don't run with that idea fully, because that statement, I took time to read it, and part of what it said, I'm trying to quote here, there is no delay in the process. It is simply following the law to the letter to ensure that only those duly qualified benefit from the president's mercy. So they're saying, how would you interpret this? Is it that, they've listened to the people that they are going to review, or they're just playing politics? Because that language there is saying there is no delay in the process. They are just following the process.
They are not following the law. The process is the committee would meet, the committee would look at the names, ensure that the people who are pardoned by the president are people who meet the requirement. Now, what we have is that the president has pardoned them, and that is when the committee is now reviewing. Do you review before pardon, or do you review after pardon, or you review before pardon? So the Attorney General's statement, with all due respect to him, somebody I respect very well, a very senior lawyer, somebody, a man of few words, with all due respect to him, that statement is not simply following the law. It's a political statement, because they ought to have reviewed that list, ensure that those on the list are those who actually merit it. Because we can't be fighting insecurity, fighting corruption, fighting drug usage, and fighting criminality, and people who are convicted last year, people who are convicted 2 years ago, people who sold Nigeria, who were convicted for selling arms, are those that are being pardoned by the same government. And then, because of the cry of the people, you are reviewing the list. I expected that as government, they would have gained more mileage by saying, well, we made a mistake, but we listen to the cry of the people, or we listen to the call by people and well-meaning senior lawyers in Nigeria, a lot of Nigerians, and we decided to look through the list again, maybe because it was an oversight on our part. Hold on to technicalities of the law to say, oh, yes, we are simply following the law. That's not following the law.
I guess Falana and gentlemen like yourself have also put their voice to that matter. We'll see what happens in the coming days. But let's talk quickly about the Nnamdi Kanu's case. Now, Shaware is celebrating the court's decision. Is it a dismissal, or the fact that the court has asked that they serve notice to Shaware, but it just fell after the day of the protest? Explain it to us, please.
Normally what applicants like the police do in cases like this, they rush to court without serving the other party. They go get an ex parte order and then ask the court to issue a restraining order and ex parte injunction to restrain the other party. And in most cases, the other party is not even heard, it's not in court. But in this case, the court has said, no, I will not grant you an ex parte order. Put the other party on notice. The two of you should come before me on Tuesday, argue for, put your argument for and against before me, and then I'll now know whether to grant, because it would be unjust to grant a restraining order against the protest when I've not even listened to why they want to protest in the first place and under which laws are they protesting. So that's what the court basically said. So it is not true that the court has dismissed that application. The court simply said, state the application, come back and argue before me, but let the other party, all the parties be before me. But I think also, quickly, I think that the federal government actually, with this, the list of the pardon also is generating the call for the release. But if you follow the case genuinely, you'll find out that the federal government has closed its case. The government has closed its case against Nnamdi Kanu. It is for Nnamdi Kanu to open his own defense. And then the last time, initially, they filed a no-case submission, and the court dismissed the no-case submission and said he has a case to answer. And then subsequently, he applied for sick leave, medical treatment, that he has a terminal ailment, and was subsequently examined by the Nigerian Medical Association Board, and they said that there is no ailment that is life-threatening to him, and it is for him to open his defense.
Okay.
But like typical of everything in Nigeria, Nnamdi Kanu, the monster was created by government insensitivity, government injustice, and then the release of criminals under Section 179, under the guise of pardon, also has emboldened this call for his own release also. Otherwise, trial is ongoing, is for him to open defense.
Not to stress on that, but I wanted you to also look at the flip side of the coin. I know that some of these dates are decided based on availability of, court space and other contingency. But knowing that the protest was slated for the 20th, yet ruling that they will reconvene on the 21st, is that an implied win for those who are going for the protest?
What the court usually do is to ask parties to maintain status quo. If you look at that judgment very well, the court will ask all parties, don't take any step that will force a fait accompli on the court. What it means is, Shaware, don't go on any protest, and police don't also harass them until you come back before me on Tuesday and let me decide one way or the other.
Well,
if you look at it, there's no way the court will not say in that judgment that parties should maintain status quo pending the hearing and determination of the motion on notice.
Well, it's looking like Shaware is not going to listen to that part of the judgment because his statement already implies that the protest will go ahead. But let's look at the police concerns. The reason that they went to court, the U.S. Embassy has already issued a statement cautioning their citizens from going out on those days, on that day, one for traffic, clashes with police and all of that. The police is saying this might cause security challenge and, escalate to something else. Are their concerns valid? And is there a better way they could have gone about this than going to court?
The police is empowered to constitutionally maintain law and order. When there's call for protests like this, what the police should do is to ensure that the areas they know that are flashpoint to strategically position their men and also give provisions, give security to the people who are protesting and ensure that they are orderly. Because we also see ruling party protests and they get police protection. It is when police becomes confrontational in some cases that protests, skyrocket and then go out of hand. So the idea of going to court via an ex parte and trying to stop the protest, it's also ill-conceived. It is not properly advised. What the police ought to have done would be to ensure that they provide security, for the protesters and ensure that they are orderly, because Shaware had said it is going to be a peaceful protest. But then also, there are some persons, they say as our faces are different, so our heart desires. There are some persons also, Shaware might not fully be in control of the crowd, because there are some persons who might be coming there for something untoward, for something totally different from the ideas of the protester. That's why the police need to ensure that there's civility, that there's professionalism, highest level of professionality displayed. It is when the protester goes out of hand that the police now can begin, to find a way to stem the tide. But rushing to court to get an order and then now use that order to begin arrest people indiscriminately, it is unprofessional on the side of the police.
I guess we'll have to see what happens in the coming days. Thank you very much, Boris, for speaking with us. We appreciate your time.
My pleasure.